Are you an F1 student but just married or are about to marry a US citizen?
If so, then this video is exactly the starting point for your upcoming journey.
We cover how you can adjust status from F1 and which forms you will need to use, whether you should maintain your F1 status, and everything else about your transition here.
Hey there, and welcome to our channel.
My name is Margarita.
And my name is Dixon.
We make videos for people who will be going through the marriage adjustment of status process.
Despite being immigration lawyers, the main purpose of our channel is to give you guys the confidence that you need to go through this process entirely on your own, without a lawyer, just like we did.
So be sure to subscribe and hit the bell so you're always up to date.
Okay, so you've come to the US on an F1 visa, but met someone, fell in love, and want to get married.
You probably have some questions about how this will all impact your current immigration status and generally how your journey will look like.
So first, can an F1 student even get a green card after marrying a US citizen?
The USCIS states that to apply for a green card, you must be eligible under at least one of 8 different categories.
In the case of a marriage green card, an F1 student would be eligible to get a green card through family. More specifically, that student would be applying as an immediate relative of a US citizen, which includes being the spouse of a US citizen.
So yes, an F1 student may get a green card after marrying a US citizen, but so long as they meet all the USCIS requirements and overcome one important caveat.
They need to overcome the inquiry by the USCIS into immigrant intent.
This is why you will want to stick around to the last 2 points, which are particularly relevant to F1 students when the USCIS evaluates their intent.
The next question F1 students often ask us is, where do I start? In other words, they want to know how to adjust their status.
To apply for a marriage green card, F1 students will need to file forms I-130 and I-485 in addition to a few other forms that we will cover in just 1 second.
Form I-130 is called the Petition for Alien Relative. This form is completed by the US citizen to establish their relationship to an eligible relative who wishes to remain in the United States permanently and get a permanent resident card, which is also called a green card.
Form I-485 is called the Application to Register Permanent Residence or Adjust Status. This form is used to apply for lawful permanent resident status if you're applying from inside the United States.
And by marrying a US citizen, you should file these forms together. This is one of the immigration perks you get when marrying a US citizen.
We made a video explaining all the perks you get, so be sure to check it out.
The next question we often get is, can I apply for a work permit and how long will it take?
First, it's difficult, if not impossible, to predict how long the USCIS will take to process your case or specific things such as work and travel documents.
However, you do need to know that recently the USCIS has made a major push to get new applicants processed as quickly as possible.
So for instance, when it comes to members of our program, they often get their green card very fast and sometimes without ever getting their work permit.
This is the case for a number of reasons, but nonetheless, the USCIS has sent out a policy update that they will waive interviews for straightforward cases as long as certain requirements are met, which will fast-track your case.
We've linked the requirements in the description below, but ultimately the requirements make it important to submit a more complete application so that the interview isn't necessary.
And as far as whether you can apply for a work permit, you absolutely can. As mentioned earlier about submitting your I-130 and I-485, another perk of this concurrent filing is that you can file for your work permit with those 2 forms as well.
And this means that you won't waste any time in getting the USCIS to process your entire case.
And taking into account the new policy of waiving interviews, this means that you have the opportunity of getting your green card very fast.
And there's actually one more form you can include with your initial application as another perk of this concurrent filing.
Let us know with a comment if you want to know what this form is, but as a hint, it has to do with your ability to travel abroad.
Alright, so now let's discuss the important points that the USCIS will look into in order to determine your immigrant intent.
Which relates to the next commonly asked question, which is, should I maintain my F1?
First, it's generally a good idea to maintain your current legal status even when applying under a new process such as the marriage adjustment of status.
Now, this is because the USCIS will treat both as separate processes, which will likely have no impact on each other.
And also, you don't want to unnecessarily limit yourself and/or place yourself in a vulnerable position.
Which leads us to the next reason you would want to maintain your F1 status.
And this is due to immigrant intent and fraud.
Basically, the USCIS will evaluate your current legal status when determining whether to approve you for your marriage green card.
And F1 visas are non-immigrant visas, which means that you were granted your F1 on the basis that you had no intent to remain within the United States.
So, consider how it will be understood by a USCIS officer that either you didn't attend school or you attended for a very short period of time.
You, of course, might be inclined to argue that you cannot afford to pay the high international student fees, but you should understand that this is likely not a persuasive argument, and why not?
Because part of the approval process for your F1 was based on finances and your ability to follow through with your education.
But that being said, we've seen a number of cases where people dropped out of school and of course still got their green card approved. Just keep in mind that these things are very fact specific, and the answer to whether you should drop out or you should keep studying depends on your particular situation.
Finally, what if you and your US citizen spouse are not living together?
Living together is very important to the USCIS when evaluating marriage green card applications, which is funny because living together is not a requirement, but this is something they closely scrutinize.
It is a strong factor they use when determining whether your relationship is real or not.
But often F1 students and their spouses do not live together and sometimes even live in different states.
And this is often the case because the F1 student lives on campus.
While not living together generally would raise red flags, it is possible to overcome the scrutiny in your case.
First, if you haven't lived with your spouse since you were married, it's essential to include a strong explanation as to why you've had to live apart.
Couples who do not live together should provide a letter signed by both spouses explaining why they live apart, for example, work or school, the day they intend to move in together, and the location where they plan on moving to, if available.
If you honestly and thoroughly explain your unusual living situation and provide alternative evidence of a genuine marriage, the living arrangement itself should not prevent you from obtaining a green card.
And in addition, you will want to prepare an incredibly strong application.
Which is exactly what our marriage immigration method is designed to provide you.
Apply today for the winning strategy used by our members and get access to our private immigrant community who post successful tips, tricks, and strategies daily.
Link is in the description below.
Otherwise, thank you for watching.
Subscribe, click the bell, comment, and we look forward to seeing you next time.